All right, so let's start again. Good afternoon. I suggest that we give now some 20 to 25 minutes to each one of the two discussants. And so I will ask you to add something from your own perspective. Okay. So I would very much appreciate if you don't interpret your role as discussants in an extremely literal and strict way, okay, considering also that you have also some contribution, if nothing else, because of your scientific background, which leads you to stress different features of the same legal phenomenon. Of course, we also expected you would give some hints on the general discussion. And then, again, I would like to have a discussion among all of us. And hopefully, after a free general discussion, we may be able to select one or two topics that we can focus on if we want to go deeper into that particular topic. Okay, so if you agree, we give the floor now to Laura Baccagli.
Thanks, Professor Toniatti, and I'm glad to take part to this seminar. And first of all, let me say a special thanks to everyone for the talks that I've listened this morning. What everyone outlined today, it's very interesting, even from a civil procedural point of view, which is the perspective through which my analysis is going to be developed now. Let me start with a preliminary remark about the essence of arbitration. Whose proper feature is allowing the party to choose which judges can decide their dispute and which substantive law the umpires shall apply. To be honest, the presence of a panel of religious umpires is a widespread reality in a commercial litigation. There is a great number of awards given by umpires who belongs to the Islamic community, for instance. And this is because, obviously, the party have decided by agreement. Anyway, the question that I'm going to refer now is quite different and even new due to the growing claim of religious community members to regulate the matter of personal status under their religious law, with effect in the civil countries. The heated debate that exploded in the United Kingdom and Canada due to the existence of Sharia Council tribunals marks a strong example of that situation. Sharia Council would represent a kind of Islamic arbitral tribunal who judges upon family matters according to Islamic law. Anyway, the existence of religious tribunal who settle this kind of dispute is not typical only of a reality, an Islamic reality. In a nutshell, the question that demands to be resolved now could be expressed as follows: whether and how this such kind of private judgment can be of effect in a civil countries. It's worth pointing out that the question is quite different of that of recognition and enforcement of civil court judgment. Even in this case, the country of recognition can bar the recognition and enforcement of a foreign judgment, but the country of recognition cannot bar the exercise of foreign jurisdiction. The problem we are referring now, it's quite different because arbitration represents a kind of private jurisdiction. That is to say, a manner to limit the exercise of jurisdiction by the state. This is the reason why the problems I'm going to face now can be summed up as follows. First, does the state allow arbitration on family matter? Secondly, are there any grounds to deny the recognition and eventually the enforcement of an award? Third, if not, what if the umpires decide under religious law? Last, is the solution quite different whether the award is a domestic one or a foreign one? Obviously, the answer of questions I put could be different depending on the choice that every law system makes. Due to time constraints, reference in my talk is given only to some civil law systems like Italy, Germany, and French, and to some of common law systems, some states of US, Canada, and United, if we can consider Canada like an example of common law system, and the United Kingdom. Albeit different solutions, the analysis reveals that, generally speaking, every law system recognized an award provided that two grounds at least are met. First, the matter can be referred to arbitration. Secondly, the award shall be in accordance to public policy. As far as Sharia Council award on family matter is concerned, suffice to say that it could have effect in a state if the family matter can be referred to arbitration and if the award is in accordance to public policy. The conditions which I referred to are not of the same importance. First, there is a prejudicial matter of arbitral jurisdiction's exercise. It has the arbitrability of a dispute. Incidentally, let me specify that the category of arbitrability of a dispute is not in the shows of common law system. It's typical of civil law system. Anyway, this expression is well known in the conventional language of international arbitration, and it's referred to the problem of matter who can be or cannot be referred to arbitration. Secondly, there is a question of choice of law, which is both substantive law and procedural law, as far as public policy respect is concerned. As for now, let me point out that broadly, civil law systems show a more restrictive approach insofar they deny the arbitrability of family matter, while common law system trend is to demand only the respect of public policy. Anyway, this is only a first sight impression because the outcome is the same. The practical outcome is denying religious arbitration on family matter. Let's start with the analysis of the ground of arbitrability of a dispute, which pertain to matter who cannot or can be referred to arbitration. As a preliminary remark, it's worth stressing that insofar the state recognizing the use of arbitration, it limits its jurisdictional power. This is the reason why the state exercises its control upon a word. And the control of the state could be of two different kinds. First, an ex-ante control. The state decides what can be or not can be referred to arbitration by statutory law. This is the typical case of civil law system. Secondly, there could be an ex post control. When an award is given, the award shall be recognized and enforced in the state. In that case, the control is up to the court. The court shall verify if the award can be or not can be given according to the state of recognition. What I have just described is typical of every law system. Each one is free to decide which matter can be settled or not can be settled by award, but the result, the outcome is the same. If the law bars the arbitration for some disputes, the effect of award is the same. So the award cannot be recognized in the state. As briefly remarked above, civil law systems do not consider family matter as something to be decided by a word. But let me point out that the expression family matter is very generic, nebulous. From a civil law and a civil procedural point of view, this expression, family matter, involves several claims. First, divorce or legal separations claims. Second, disputes upon patrimonial rights, which arise from the dissolution of marriage or during the marriage. Third, children custody. Fourth, disputes upon no recognized union, I mean more uxorial relationship, even between people of the same sex. Last, heritage claim. In my talk, for time constraint, attention will be paid only to dispute with regard to spouses at the moment of marriage breach. So, changing of personal status, dispute related to children custody, and division of assets who belong to spouses. Assuming that point of view, the analysis of some civil law system, precisely Germany, French, and Italy, reveals a common trend to consider personal status, status of marriage, or position of children, like something not to be settled by arbitration. It's a common belief that the argument of civil system against family matter arbitration, insofar the state leave out such kind of a word by statutory ban, depend on how those systems consider personal status. Only statutory law can regulate personal status. Only civil court can decide upon them. No parties' agreement can modify them. One should consider that, in a civilian perspective, the distinction between what is or not is referred to arbitration is based upon the criterion of party disposition of a right. That is to say that a right or a legal position can be decided by arbitration only if the party can submit an agreement upon this right. Only if the party can decide to transfer the right to another person, or decide to submit an agreement, a settlement upon the right. Personal status has been even considered as a crossroads between private and community, a matter where state wants to exercise their entire control. So, such kind of dispute are to be decided only by court. It's not by chance that, for example, in the Italian system, Italian Code of Civil Procedure provides the presence of public prosecutor in a jurisdictional proceeding that involve personal status. This is the reason why statutory laws do not allow arbitration on personal status. Choose to proceed in order. As for Italian system, reference is to be given to Article 806 of Italian Code of Civil Procedure that has been recently amended by statutory law of 2006. Actually, unlike the foregoing provision, the current one does not expressly state that personal status and matter concerning legal separation and divorce cannot be settled by an award. In other words, statutory law does not refer to this specific matter as something ruled out from arbitration. Anyway, let me say that nothing changed compared to the past. Simply, the law opts for a general criterion and consider not referred to arbitration every dispute concerning right or law positions that party cannot dispose by agreement. Since personal status is considered like something that people cannot dispose upon, no arbitration on personal status matter. The situation is the same in France, where Article 2060 of French Civil Code rule out the arbitration upon issue that concern personal status, divorce, and legal separation. And the same conclusion could be drawn as for German law. Broadly, paragraph 1030 of ZPO allows arbitration only upon patrimonial rights. Therefore, as for family matter, paragraph 606 and 640 of ZPO ban the private judgment when disputes regard divorce and legal separation. However, it's worth pointing out that the law of those systems rule out from arbitration only questions which are strictly related to personal status. The point, in my opinion, is of importance. Choose to give an example on family matters. Italian academic scholars and courts are of the opinion that no one can obtain divorce by an award. But if you have a patrimonial right between the spouses can choose arbitration, can opt for arbitration. Rebus sic stantibus, which is the fate of religious award by Sharia Council, for instance, when set about divorce between Islamic people, could it be recognized or enforced in a civil law systems? A distinction will be drawn. First, one should consider what happens if the dispute is strictly related to the change of personal status. In such case, private judgment cannot have effect in the civil system. Certainly, a different solution could be suggested if the award set a patrimonial dispute, which depends on personal status change, when divorce had already been stated before a civil court. In such a case, the award could be of effect in a civil system, provided that public policy is respected. Last, one should consider what happens if the award set not only upon the personal status, but also upon some patrimonial rights arising from the changing of personal status of marriage. Can the award have a partial recognition in the civil system? No doubt about refusing of recognition for such an award where it declares the breach of marriage. But what about the subsequent statement that, for instance, states that marital home belongs to wife? It's my opinion that a partial recognition could not have effect in the state, because the statement upon patrimonial rights is subsequent in respect of the divorce one. And since the divorce statement cannot have effect in the state, even the subsequent statement cannot have effect in the same countries. It's worth highlighting that the just mentioned solution should be the same, although the award, even a religious one, is not a domestic one, but is a foreign one. That is to say that the seat of arbitration is outside the system. For instance, an award given in Canada or given in a country that want to be recognized in Italy. The solution that I put above is the same in this case. Provide the application of New York Convention of Recognition and Enforcement of Foreign Award. According to Article 5, subsection 2 of this convention, the proper authority in the country where recognition and enforcement of a word is sought to give it. According to Article 5 of Convention of New York, the Court of Recognition shall check whether the matter of the award is to refer to arbitration according to his law, and if the award is in accordance with the public policy according to his law. So it's the law of the state of recognition who decide if the matter of a foreign arbitration could be referred in arbitration according to his law. If not, the award cannot have effect. If things were in such way in civil law system, there is not a greater freedom of invoking arbitration for all family disputes, at least if they concern directly a changing of personal status. Thus, there's no future rebus sic stantibus for religious word on family matter. But let me stress again that it is not a question of religious law. The problem is a prejudicial one. Anyway, something probably could change in the future. It's my opinion that the position of some European states, insofar they consider personal status like something under public control, is quite contradictory and outmoded. There is at least two kinds of reason that can justify my objection. First, there is the so-called uncontested divorce, which is just in force in several states. I refer to the possibility of the spouses to obtain divorce under certain circumstances only by a formal control of the court. In many cases, refer to the lack of the children. The divorce is not by fault. There is not a real control of the state. The control of the court is only formal. Secondly, I refer to the so-called full uncontested divorce, which is yet not in force in Italy, where it represents the focus of a current debate. Reference is given to the faculty of the spouses under certain circumstances, precisely no presence of children and no disagreement about asset to divide, to dissolve a marriage without appearing before court, only by an agreement submitted by notary or a specialized barrister. Something like just happened in France. The trend is to consider divorce, especially when there are no children, like something who belongs to private sphere. Children are considered like matter where the law system wants currently to exercise jurisdictional power. Something about the position of common law system. The position of those systems compared to arbitration upon family matters is quite different. It's not by chance that the arbitration in family matters is generally ruled by statutory law in common law system, despite of what we have just highlighted for civil law systems. Likely, what is different is the approach of the matter of personal status, which is mostly considered like something upon which the party can dispose. Anyway, looking at the issue more closely, the analysis revealed two interesting facts. First, despite of civil law, the approach of common law is not uniform. Second, although the diversity between civil law and common law, the outcome is the same. In other words, there is a common trend to refuse recognition of religious award on family matter, especially if the award was delivered on changing of personal status. First, let me briefly refer to the uneven position of common law about the arbitrability of family matter. For instance, as for the states of US, federal rules of arbitration make free the state to rule on arbitration on family matters. This is the reason why some states of America decide to apply the revised Uniform Arbitration Act of 2000, which are federal rules. This is the case, for example, of Colombia. While other countries provide a specific statutory law. This is the case, for example, of North Carolina or Indiana. Even the position of state of US toward matter we cannot refer to arbitration is different. Choose, for instance, look at the point of view of the state of New Jersey. In New Jersey, the law allows a couple of spouses to bring a suit before an umpire for divorce, dispute related to patrimonial right and children custody. On the contrary, the position of North Carolina, which allows family arbitration only upon patrimonial family matters. Otherwise, the state of Indiana allow the arbitration even upon divorce matter. Canadian position is quite peculiar. For sure, it represents an example of allowing arbitration on every family matter. So divorce, so changing of personal status of marriage, children custody, and patrimonial rights arising from the end of a marriage. But it's worth pointing out the recent position of self-restraint about the applicable law. I refer of the Amendment Act of 2006 that changed the Ontario Family Statute Law. Currently, according to this statute law, any decision made by a third party in family arbitration cannot be of effect if it has been delivered according to the law other than the law of the Ontario or other than the law of another Canadian province. Canada allows arbitration even for change of marriage status or upon children custody, but the state prevents the party to choose the applicable law under which the umpire have to decide. That is to say that there is no power for the parties to opt, for example, for Islamic law on family matter. As a matter of fact, Canada law provides even some particular feature for arbitration. So arbitration cannot be a common person, but arbitrator, the umpire, has to be a specialized barrister or a specialized psychology and so on, and provides some specific rule to ensure the equality of spouses before arbitration. This could be a reason why the state denied the use of Islamic law. Lastly, I would like to briefly remark the position of United Kingdom. Under Section 1 of Arbitration Act of 1995, parties should be free to agree how the dispute are to be resolved, subject only to such safeguard as are necessary in the public interest. Even in the United Kingdom, people can resolve family matter by a word, except for those disputes which involve directly personal status on family matter. In the Jure Condendo perspective, so assuming that arbitration on family matters will be allowed in the future, it's a matter of identifying which other grounds can bar the recognition or the enforcement of such kind of a word, since it has been given under a religious law. The question strictly pertains to the violation of public policy by that religious law, which was applied by umpire, or by the procedural law the arbitration decide to apply to deliver the award. Something similar happens right now when an Islamic couple divorce before a court of the orange countries according to Islamic law and apply for a recognition of that judgment in the European state. I'm aware that this is not a precise subject of the seminary. Now we are referred to arbitration, so a word. Here I refer to a foreign judgment given by a civil court. But I'm persuaded that what I'm going to briefly say now could be of some interest whether law system will change their position and allow the arbitrability of a family dispute. In such case, the problems that demand to be resolved are the same of those which arise from the recognition of foreign judgments given under Islamic law, more precisely, given by a secular law whose principles was based upon an Islamic law, or given by a religious law if religious law is referred to statute law of the countries. Whatever the case, the Court of the State of Recognition has to verify whether substantive or procedural law applying by foreign judge could be in accordance with public policy of the state of the recognition. Actually, defining what is the public policy is not an easy operation. One could say that public policy is a set of principles normally inferred by the Constitution, which found the legal system in a particular historical moment. Such kind of principles represent the cornerstone of the ethical framework, social and economic life of the national community, giving it a well-defined physiognomy. Public policy pertains to substantive law and procedural law, that is to say, equality of the parties before judge, principle of audiatur et altera pars, equality to give evidence to the facts. The accordance with public policy does not result merely by an abstract comparison between what national and foreign law state. It's up to the court of the country of recognition, deciding case by case which effects the foreign law has upon the dispute. Thus, the foreign judgment can be recognized if the effects are in accordance with the public policy of the state of recognition. Everyone knows that the Islamic religious religious law makes an husband free to obtain divorce in an extrajudicial way by the bar talaq when he decides to repudiate his wife. Under the law of some Islamic countries, the divorce can have effect even when the wife is not aware of talaq. Divorce, 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 talaq, 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 and the marriage is dissolved. It means that divorce can be obtained otherwise than by meaning of a judicial proceeding and without making the wife to have a right to be here and defend herself. In such a case, no one doubts that divorce cannot be of effect in European countries, where the divorce must be given only before a court and where the presence of the defendant before a judge has to be granted. But what happens if the divorce was delivered by a foreign court and the wife was claimed to defend herself? Here, one could say that there is no branch of principle of audiatur et altera pars. For sure, yes, but the analysis of the opinion of secular courts, when they seek to recognize such kind of judgment, show a general trend to bar the effect even of those judgments, since the repudiation is something not in the shows of European countries, as many English and Italian case law show. This is only an example to understand how less the religious award, although they were allowed it by civil and common law system, could be of effect there. To conclude, I'm increasingly convinced that the real question is not whether or not allowing arbitration on family matter, but whether or not accepting the application of some principles who do not belong of a common sense of the state where the recognition is demanding. Thank you for your kind attention.
Because your presentation has been very technical and it contains so many major points which I think that somebody may have some questions. So as we did this morning, quick questions for quick answers. Do you have any? Well, I do. Could you tell us something more about the rationale for the non-arbitrability of matters of personal status?
Why civil system decide that family matter?
In civil law systems, yes. You take for granted that we understand why, and I don't, personally. And as a matter of fact, I feel also a little bit troubled. It seems that my privacy is a little bit invaded. Of course, personal status is public.
Okay. The category of arbitrability of a dispute is not in the shows of common law system. Normally, common law system bar the recognition of an award using the category of contrary of public policy. Okay, the approach of civil system is different. Why?
That's my second question. So perhaps, could you give some idea, because for instance, if you take the language of international private law, the reference is to ordre public. And it is the ideal ordre public, not the material ordre public. So I wonder, is public policy next to ordre public? And what is the origin of the language? Why public policy?
Public policy is the English translation of ordre public.
It's a poor translation, I'm afraid.
Okay.
Yeah, but don't you agree that it is a poor translation?
If you read the New York Convention of 1958, and if you read the French version and English version, you have ordre public and public policy.
As you said,
okay.
Sorry. If I may, I suppose that this is why in academic language, our colleagues of English language don't translate ordre public, and usually the reference is to ordre public rather than to public policy.
The use of public policy is a very common expression. No. Public policy is used if you want to refer to a judgment or a word to be recognized or to be enforced in England. So, but I think your question is quite different. So the approach of a civil law system and common law system is different, but the outcome is the same.
Right.
Okay. I mean, I think that the different approach depends on the fact that in civil law system, you know the distinction between right and action. In common law system, this distinction is not well known. So it's more easy for a civil law system decide in an a priori form that you cannot refer upon this one and this one and this one matter. The approach of common law system is different, but the outcome is the same. I can give another example about bankruptcy. You cannot refer to arbitration bankruptcy. Why? An Italian lawyer answered you cannot, because it's a matter that cannot be referred to arbitration. In England, in the United Kingdom, sorry, a lawyer answered you cannot refer, no, an award upon bankruptcy is contrary, violate the public policy. It's the supremacy of the civil court to decide about bankruptcy.
Any other quick question for a quick answer?
Well, I have to say that I have a full page of notes. I loved your presentation. I think that my main concern was that when I was hearing your presentation and thinking of this morning the presentation on the Sharia councils, I was somehow puzzled by the question, is enforcement really what people who go to in front of Sharia councils, what they want? Is this what they want? Do they want enforcement in the, for instance, in the UK system, or rather do they want something else? Because my sense is that they want something else which actually the state cannot offer. And the state cannot offer because it lacks the legitimacy or the authority to actually issue a ruling on religious matters. Okay. So they refer to these other bodies which might just lack legitimacy as much as the state, but they draw legitimacy from other sources, just, maybe just swearing a galabia or growing the beard or whatever that is. So in a certain way, your presentation on enforcement, I think it opened my eyes on how somehow useless my report was for the European Commission perspective, because it shows that the European Commission doesn't even know the regulation of its member states, because if they really want to push the southern shore member states to introduce ADR forms on family matters, and they don't even know that if they do introduce them, they will not be enforced in Europe. I mean, why are they pushing them to introduce ADR unless they expect that the European systems will move into the acceptance of ADR forms?
I would like to answer you, giving you an example about how is the restrictive position of European countries and European Union. For sure, you know that now is a new regulation, a new European regulation about applicable law of divorce is in force. I refer to Regulation 1259 of 2010, who allow Parte to submit an agreement to choose the applicable law of divorce. But if you read more closely the provision of European law, you know that the possibility to choose the applicable law for spouses is very restricted. And even if you can choose the applicable law to your divorce, if the court decides the chosen law is not in accordance with public policy, you cannot ask to the court to apply the law you have chosen. That is to say that I think that at the moment, currently, there is no space for agreement. So for family, even the judicial, if I were clear.
If you then you give me time for another.
What about the Hague Conventions? Sorry? The Hague Conventions, did they regulate at all arbitration?
No.
They don't? Okay. Thank you.
My questions. I very much appreciated the distinction that was made between what the request purpose for making a request. In other words, you try to obtain something which is effective from the legal system, but which may produce effect in another legal system, and also overspoken about it. Could distinction like causa petendi and petitum? The petitum goes to the legal state system, but the causa petendi to achieve effects in another legal system. That's one question. Second question. That we recall distinction between legal plural weeks and wrongs in a I don't see really any choice. Completely hard system. It's not solid legal plural. In other words, here we don't have any recognition of effects as the conformity with this. So the policy requires not only very strong, even in a common, it operates as in French constitution. Indirectly, you do have a hierarchy of rules, and in this case, and that's why perhaps I was so, it's difficult to consider public policy the higher rule background. What it is, isn't it?
I think so. I'm persuaded that the restrict position of system especially the position of children. I mean, I'm persuaded that some can change when it's only between spouses. I'm persuaded the personal status will become private. Okay. As a matter of fact, the presence of union between people which are of the same sex, which is recognized in state, so that has to be changed about married. But I think that the presence of the public of policy is so because the presence of children.
If I may, the fact to couples is not as recognizing effect to them.
Yes, now.
Married,
now.
so it's not the same.
Okay, now, but I'm persuaded that something could be changed in future. What I think that could be possible is the use of arbitration for all the family matter. No, I don't think so.
Okay.
Let me sometimes to think about the answer of the question. Okay.
Any more? No? So then we floor to David De Sassari, very interested. You don't understand. If I can sit comfortably and take notes. So you have the floor. As long as you have the microphone.
I have. Okay, thank you very much. I start my talk review our state, I mean Western legal tradition state, can recognize, positively recognize religious law, because I think this can help. A first way, I think, is when the state merely recognizes through the pieces of law some conducts of daily life which affect religious law. For instance, there are statutes that try to accommodate the mass Jewish concerning the animals. Or another example is an statute that allows sick to wear a helmet when they ride a motorcycle. It might be also judged that the of anti-discrimination rule or free religion lie otherwise rule. I mind the case of the Canadian Supreme Court, the Botanics, where the court consideration of the principle as a school rule that ban the wearing of weapon when it applies to a young sick boy that was prevented from wearing the kirpan, the ritual dagger that the sick are compulsorily obliged to wear. A second, more intense way the state can recognize religious law is when the state gives to religion the public dispense. For example, we have ecclesiastical court can pronounce an to Catholic marriages, and the arbitration in the United Arbitration Act 1996 could arguably be used in this sense if, as I understood, in fact, it is used as this. However, we have a problem in the sense, and this relates somehow to the issue of public policy, in the sense that when the state enforces a religious decision, it must ensure that this decision is in line with human rights standards. And I have in mind the Pellegrini versus Italy case. It was decided by the European Court of Rights, and he states it for breach 6. And it was a case where it enforced an ecclesiastic decision, but the court found this decision was in breach of some fair trial rights. The state may recognize religious law decision. It should be sure that it respects some rights standards. If a state can recognize religious law by means of national law, here we should be aware of the fact that, as I think law said, private may make to the law of the country, and the law of the country may statutory more by religious law, or in canon law applied, it might be religious law. National private should have different goal. One is the idea of community of nations and is trust jurisdiction, but the other is to offer, to grant the state with instrument to hamper, to block the possible application of a foreign or for decision. As mentioned, this is the policy or oblique exception. And some countries of Europe, I'm aware of the French and the Belgian case, are showing an increasing negative attitudes toward the recognition of traditional Islamic law, such as polygamy and repudiation. Whereas past, at least under certain circumstances, they recognize polygamy and repudiation decision pronounced by state of origin institution. Now they don't anymore. In the Belgian case, of course, especially one of the parties is acquired the nationality of the recipient country, who is a long resident. This increasing attitude toward the issue of following the civil rights, and this is important. I think the line of the between judges, not with the conclusion of international bilateral agreement between the state involved, Belgium, Morocco, France, Morocco, should allow for the recognition of such decision, at least under circumstances. And not only the fact that countries introduced many amendments to the FEM, likely to make them with standard and to this decision to be recognized by European states. This may push immigrants to the country, to state course. However, matters because what happens if this decision made, the European should recognize their country of origin. So I have a photo to Gianluca, and this notion of policy and the Maghreb countries. I wonder, as a reaction to the inclusive attitude of France, they are to build different policy. the immigrants are like trapped. The public is not only the only that allow the European country to do the application for aim. Another instrument is the criterion that these members choose select the substantive law applicable to parties. And as I think Laura already mentioned, there's an increasing move towards the utilization of the habitual residencies of the spouses rather than the common nationality, exactly because this allows to apply the lex fori law, not the country of origin law. And even in those countries where nationality is still important as a connecting factor, here we face the problem of dual nationality. And to this extent, we should be aware of the fact that European states were quite contrary to the idea of dual citizenship. And we have the 1997 European Convention that moved from hostility toward neutrality, which means there are still states that are against double nationality, which again led me to ask to Gianluca, which are the consequences at the level of the Maghreb or the other Islamic countries, in the sense, are they happy to the idea to permit, to allow their citizens to renounce to their citizenship or not? Okay, so I think we have three situational corridors which stay positive, recognized law, as I said, but the case of the Sharia Council that Martel told us today fit, as I understood. Because here, as she mentioned, we have two parallel jurisdictions. They don't communicate to each other. So I have to say that my first reaction, my first thought is that it was why people go to the Sharia Council. Don't they need a formal recognition at a certain point of their life? Don't they need such recognition? Because I think that consequences may be severe. I know if, it's really important, but how this of the Court of Human Rights concerning consequences for the law of recognition of marriage. In this was very similar, and a woman that for a responsibility pension, but the marriage was only really marriage and it's not recognized. It has not been fully recognized by the state, and so didn't pay for this. The two cases were decided in a different manner in Court of Human Rights. In the case, the Media's case was paid. Here, the Court of Human Rights found that pain was in of Article 12 to marry. But here, the case is peculiar in the sense time. There was not the possibility for the, according to Spanish law, to marry and with religious marriage. Whereas in the case of Egypt to Turkey, here has made clear you need to register marriage, and the Turkish Act consists of this position. Court says the state has an obligation to recognize any effect all this religion. So this we should there is, as I have heard many cases does not marry officially. Still, why this go there? Suppose it is social acceptability with a community. I wonder there might be another reason, it's just speculation, as I told before to Mac. And this is if this ruling that Sharia made are recognized by the United Nations, okay, if they are recognized by the origin institution, because this change the sense that I can why if they want to profit this decision. If this is, then other question that is, I wonder whether the national origin migration key factor in order why in countries, at least my best knowledge, other European countries with a percentage migration does not, at least knowledge such as described with refugee UK, Sharia country. And this might be explained by why in Islamic immigration comes mostly from the continent, Bangladesh, where we some of people in continental Europe, Muslim Ismaili country from Turkey. Here, as one civil law and matter the service. So this probably means a Sharia council could not be in Morocco, for example, the day before a court. Second point that much paper raised, the state provides some sort of recognition to this religious jurisdiction through the implementation of a system of official adhere. Okay, here the problem lay in the fact that the state give effect to religion, they must in law human start before. The arbitration mediated services quality be follows and provide actually I think it does work. This
prova, no, sto funzionando.
Okay, basically my point is concerning this arbitration mediation services because the idea that is that okay, we'll recognize this form as an alternative dispute to provide that you assert based on rights, namely procedural right and the risk of discrimination text. And if you do not do this, there's a criminal offense framing legal jurisdiction. But here I have some problem, and we had a little discussion concerning when we have at least. I will explain. According to there might be a case where a man doesn't want to give the divorce to do, and then can go before the Sharia Council and can try to convince someone to give this divorce. Actually, is mediation and pay, for example, the or the custody of the son. If this is the case, I don't see real jurisdiction in the sense Muslim council can do the husband. He can try to see him. Will is lacking, cannot replace his will. I don't see here dictionary at all, so know if avenue is a practical avenue. The second point is I can understand it's difficult to if this form of risk really volume, but I'm afraid there might be a problem with human rights, sense that if as interfere private decision to make issues side Parte break this autonomous, and I would say the form of association are and so you may have at least when these decisions are not required to be state. They don't want that this decision recognized by states.
Very good. So, quick question, quick answers before we the floor for just which was not so clear, or some curiosity that was by David. No, not really. Can you wait? Is to have questions, David. There are none. Okay. So it's open, and we start the debate with your options. With this.
Asked why women go to Sharia councils. Unfortunately, there is currently not search reasons, secondary sources, and the report interviewed with rights organizations, and they tell me that go to religious well, maybe also they feel it's their religious duty, but even more so because they have to deal with fierce culture and not walk around married and live life of a married woman. So they
Women, regular migrants there?
Sorry, there what?
Regular migrants.
I don't.
Regular migrants?
Regular?
Regular migrants.
No, you're right. I'm going to get to number 3. I'm doing harder. Is these links, so you get a piece of paper saying words are Informally, they the Muslim community. So, since you can show a piece of paper to the villagers in Pakistan, you can also, but they are not directly recognized formally. If you want to get the divorce formally recognized, you need to have this done through the embassy or through the Pakistani Council of, and then I cannot remember the name. So it does require another step, and whether that is actually successful is it's not that you owe or that you forget it. I asked the people at the Birmingham Sharia Council, and they said that sometimes and sometimes basically. So the best answer I'll give you. Your third question was that you that another kingdom has Sharia councils, they have a different background events, and I agree that that is indeed a source of influence. Are in Pakistanis and the continent, right? But not only because they do at a large number of communities. They say that they were soon in schools. They've got where they've translator, interpreter, and they group, and then they group the service also people, but who yeah, but still, yeah, it is a true fact that Pakistan indeed contributes to the existence. Your fourth, do I believe recognize Sharia rulings to stand in exchange for more? If I understand the question correctly, that would be a good thing, because I think the sole made by the group we should follow, and not the people who for the just for instance, and that's why I think that the other alternatives, the cases, criminal offense cases, provide a better for women to their divorces, rather giving legitimacies what unprofessional organizations.
Thank you. Yeah, yes. That's okay. Well, I just wonder if, do we want to have a second round of speakers? Perhaps I have to answer the
You want me?
Completely up
I
to
think
you.
it's so before your two questions, I think draw attention to one aspect you touched upon, which is the issue of non-nation or non-enforcement. Now there's like negative way of looking at it. We're not recognizing some communities. We're not, having their integration, and right. Also, a positive way of looking at the thing, and that allowing for a space of freedom to act up without calls of, which is exactly what the perspective for European Islam are. It is the experience of Islamic developing the presence of a strong state. It is an everyday experience in the country of origin, right? And we've seen much development on there. So the question that was in of many think of a Europe is that now we are a free state. We can actually in free debate where to take the law. So I wonder if living thing actually offer avenues for freer re-engagement. Okay, and in that, what we see is fundamentally a Twitter contest, popularity, like a talent, right? And you, Robert, mentioned velocity, right, in the web. One of the way, well, one of the earliest phenomena precise e-fatwas, right? The religious opinions that were delivered on websites. Well, before that was actually phone line, hotlines that you would call and say, you know, I have this issue, give me an answer, and then they would give you an answer, right? No authority whatsoever except the one they would claim, right? And then moved on to the web. You have the website, you submit your question, you get your answer, and again, you know, the same kind of issue. So in order to somehow, and that's a very highly debated issue in the region, even from the southern, on the southern shore, because like, you know, who are these people who are handing down these opinions on legal matters? Like, how come they speak in the name of Islam? They have no authority, right? And that has, you know, it's become famous as the al-fatawa al-shadza. That is the how should I translate shadza? The weird fatwas, right? So there has been like a movement to by conservative legal scholars to actually propose what they called fiqh for minorities, fiqh aqalliyat. And they said we need to re-engage with the sources. They had a lot of methodological discussions, very, you know, kind of, you know, higher spheres discussions, right? And then they got together, they actually formed this European Council for Ifta and Research, which was based, I believe, in Ireland. They even issued a Majalla Ilmiya for a number of years. They were trying because the figures were on the, were very conservative. For instance, like Qadawi in Qatar, or Ben Baya in wherever he's, or Luani in Cairo. So the outcome, their outcome was very conservative. So they know we're going to engage with the sources, we're going to continue fiqh for European fiqh, for European Muslims, and so forth. But the actual outcome wasn't that different from the classical fiqh. So what we're right now is like this phenomenon of, you know, the hotlines, the websites, this more structured enterprise because it had access to larger funds, right? So what we still haven't seen is like the emergence of the actual European Islam, you know, freers and engagement and all. But the fact that we still haven't seen that, if it's a good enough reason to close the avenues for that, in that sense, I would actually see the ends of enforced procedure or existing constantly possibility rather than, let's say, a limitation or a challenge. The questions that specifically public policy and renounceship, I think here spun on the amendment, especially in the Arab country. They clearly want to introduce forms that were amenable to enforcement in context because they want to connection with their electorate communities in Europe. I think that case that was presented by Talufi recently by the court was precisely that, because I mean the Moroccans went all the way to try and show their divorce was, you know, it wasn't revocable, it was final, and then get to the Valdosta decision and, you know, square one, right? So we really don't get it. I mean, I'm sorry, we really don't get it. It's true. They go a long way, try and meet, you know, the Indian standards. So, in the same way, somehow the act misrecognition by using the law of public policy. So, in the report, I tried to hammer them how interpret public policy, and I did it for issues of child custody, issues of everything. So just tell me what policy is on this issue, and I know a clear answer from any of the only clear answer I got, and what I want for cases. I don't want, ideas, theories, and word cases. And I mean, it's like same-sex marriage. Like, seriously, did you get the court case reject same-sex case in Europe? Children, child custody? Like, no. Okay, fine. I don't care about same-sex non-recognition. I want to know when public policy. Impossible. I mean, I'd go to do that. We somehow sell to me the fact that the facility on the issue is extreme, and it's somehow a response to that attempt to offer to come halfway. It's like we tried to weigh. You did get it. Now we are raising our standard. Absolutely. Well.
As read the article, took this sample in Morocco to the decision of the Supreme Court. I was concerned to decision, and they didn't recognize them because the judge was Muslim. It was 2001. I don't know. I suppose that after 2004, I don't know, things changed, but now exactly. The point is whether they would change in the sense of strict concerning this reaction we see now or in German consumer reputation.
I didn't know it's fully in line with it's unfortunate. That's the clash of jurisdictions right there. The second point is the issue, to dual citizens and the possibility of announcing citizenship. Generally speaking, the rules for announcing citizenship are very high. You usually need to apply to government, and there's usually a higher decision government president to actually allow you renounce citizenship. The fact of acquiring a citizenship without renouncing your previous usually that you will be still considered national, even though you naturalized elsewhere. Try to renounce your citizenship. Now, here regulations slightly vary, but I think that the general trend, especially all of Lebanon, you actually need to apply for renowned citizenship, and you need high decision in favor before you can actually. Then people don't do that, which means that once they go back to the country for citizenship, they'll be considered citizens, which they will avoid. So I think those are two things.
I would like to give a commenting with a discussion, an important concept which David pointed out, that sometimes recognized decision made their country origin in Italy. I will read because I'm tired, I can't speak English well. I would like to consider is related to two trends: married, domiciliate in India. 5, not the reason, but 4 or 5 years. The wife decided to have legal separation, together with the consequent alimony and the use of the house. The husband at this point opposed at both the jury and the in Italy in view of going proceeding still pending at the Sfax court. The Ascoli court region rejected both the objections. As for the former, it is that Trento of Article 3 and of 118.95 and Code of Italian. The norm is enough to root the Italian jurisdiction for end of use. The one pertaining to the separation of married couple. With regard to latter objection, Article 9 and 30 of the allow the application of the native country law for subjects of different nationalities as the law order are not. The Tunisian law does provide for the juridical of the person separation or marriage. In fact, the legal action that at tax court as petitum and in divorce are to system instead. The cases in which mediate ruling of divorce possible are nam clausus. Rules governing both separation and divorce fall under the category of law and order regulations. The Ascoli Court judicial law relative to the dissolution of marriage to be applicable as opposed to the law and order regulations of Italian legal system. The Tunisian couple consequently dissatisfied and had to cope with the relative economic implications. The husband had to pay double. This is a case of what we are discussing about.
If I can add on this, one of the cases of public policy invocation to prevent in front of a foreign judgment from Europe for instance in Tunisia, since you mentioned it, precisely on legal or body regulation, which is something that is here to be acceptable and against public policy region, so they refuse and enforce. Now, my understanding was that earlier I was a more accommodating posture to this, but we're in this legal confrontation being stricter and stricter on this this.
Only about diplomacy relations.
So let me add one more thing, which is to the Roberto's reference to the importance of translation. So that's a personal anecdote. When I was in now, a friend of mine who got married in Syria, Iranian citizen, and then they moved him to Italy. They did here. They were just their marriage here. Then decided to end their marriage and decided to end in Damascus because that was easiest. Now, formula first was the formula of mediation, divorce. So then, the formula they register in court, which is what they have to do, and then they had to get the court ruling to the official translator for the embassy, and then she could register that in Italy, right? So as she was, well, the translator was this older guy, and he had, he was not really, attached to. He was like, okay, just give me a child, print it and sign it. So my friend was like, I need to translate this. Since there was legal jargon in it, he was like, give me a hand. It was tough, so it was hard to understand some of the letters. It was like, what is this? Not mudda, which is the period in which the woman had to remarry because she's, 3, yes, the period. It was like, you can't really translating period. you know, they're going to oppose public policy here. And also, form of talaq, if you translate this repudiation, it's going to be pretty sure that they're going to reject this on public policy grounds. So it's like, you know, okay, let's try and translate it, right? So we translated in a way that then, you know, she had no problem registering it. But now this is not because we tricked the system, because the system likes to be tricked, because any divorce ruling that comes from the Southern Shore is a registration of a divorce that doesn't happen in court, right? It's just a registration of a divorce that has happened or is happening, right? But, you know, we like the form, so we like to see the ruling and the stamps on the ruling. But it's...
They were married in Italy.
Your couple. Yeah. No, my couple in Damascus. Divorced in Damascus. But translations become fundamental. Yeah.
In our system, translation is very important. Now, it's a very big problem for procedural. Yes.
I would like to give only some your case. I think that your case not involves the problem of a public policy, but a problem of respect of jurisdiction. According to Italian private international law, you have to recognize a judgment that of divorce. You have to respect the soul and not the expression which is principle. So, in other words, you recognize if the judgment, the different judge jurisdiction according to the jurisdiction of Italian civil code. Is the case, in that case, the Tunisian judge as jurisdiction Italian law not be recognized.
For this reason,
I think
they speak all and order. It's not a question of law.
Of order in that case, but to respect constitutional rule. Yes. That case
about and order.
Okay.
Not me.
The court. Another suggestion. In that case, I'm not sure the problem of there is a problem of meetings attendance. While I would like to because Italian system. It's a curious note. System in Europe, the single system that legal separation, like something who happens before. What I would like to tell me is that if two spouses want to put a marriage, first they have to be separated from the period and can divorce. In French situation, want to divorce after 6 months of marriage, no matter if you want to be live separate. So a peculiar related to the Italian system, because Italian system recognize a divorce only after a period of separation. There's a separation proceeding in Italy and divorce proceeding abroad. And the reason why they refer to divorce and separation, take into account even those actions.
Well, the fact that legislation demand for a period of time for obtaining divorce is the ground of policy act decision.
Recently, no. So, if I understand, recognize a foreign judge that directly divorce. Yes, it's not a problem in public policy. This is the reason. This is because in it can obtain an divorce sensuale before court, but to the court only.
I would like and wonder, but they would like to answer, and if nobody likes to answer, just shut the show. I think that I think leaves a number of questions open to me. The question is there a question by it is have a legal problem? Let's take it in a very and I say this because of the very answer that Machel has given to explain individuals' right to area councils. She said there is communal pressure, which I and it variety of circumstances don't relate necessarily to immigrants. You also are under some sort of communal pressure that must recall the fact you make it a entry committee, I think, a few weeks ago, found Italy in violation of the European Convention two medicals who are conscious of objection to and there are some in the country as Calabria where 90% of doctors objectors, and these undermine the right of women, and as long as the right of women in Italy is the women to an abortion is founded in the right to health of humanities of the right of, so the state does not fulfill institutional ensure the right to health of women. So I say, in spite of course, I have great medical. I don't think that their conscience is such that they are conscious to make consensus object. I think it is communal pressure. So it's not only related to immigrants. Is there such a demand? I wonder if in your research you find demands to even answer. I'm coming. Time? Take your time. Because if there is no answer, then the same as happy as we were. But if there is such a request, I'm afraid that the legal is not to this. And if the legal system is not responsive, there is a problem. Even though either Italian citizens, British citizens, Muslim, is a consideration that request immigrants, immigrants are here to stay out here for a short period. So there is responsiveness of the system. And it seems to me the various justifications for what is a request. And in the long run, we warn, I still have my doubt concerning public policy. I still doubt. I mean, the ground for opposing policy considerations, order, or also as a matter of human rights. Because human standards, you also have for religious freedom. Now, the question, like answer to, is this, if you agree with me that there is restrictive attitude concerning pluralism in general, or coming from this world? I'm afraid for a number of reasons which I really now, that there is some special concern for it coming from. I agree that world views of secular Europe and of a religion are very different and very far away from, but it's not for the system to question the validity of any religion. You have guarantee religious freedom. I think that you can be liberal, non-religious, less liberal with other religions. You also understand that you have it somewhere, so it's not really anything. But I mean, just we don't think any religious practice of smoking drugs. Think of the pays and of the support. But that's, say, typically which the jurisprudence of the court did a demand, a request. I may just reference again to what I said today. A conflict between the request of individuals for emancipation and the request of individuals for protection. So this dichotomy, I think, is quite important. This is an anthropological, yeah. And then the last point that I leave the with impression, I repeat, the degree of recognition for legal pluralism is quite low indeed. Think even in the United States there is some more. And I make to a decision of about years ago of a federal court, which declared that a constitutional amendment to the Constitution of the state of Oklahoma had violated the First Amendment of the federal Constitution. Now the amendment of the Oklahoma Constitution forbade a reference by a judge to international and very odd degree. It doesn't really make any sense. The point is the Oklahoma Constitution declared contrary to the federal Constitution, not because it banned international law from the judicial, which is a prima facie case, but it violated the freedom of religion of the individual who had challenged the Constitution of the state of the ground that Sharia not being a enforceable court, he could not write his last will to Islam and to distribute your properties after your death. Islam, according to Sharia law, is part of your freedom of religion. You see, I said earlier, sorry for again, in the states, some legal systems will answer because it is a piecemeal, it is a partner, cannot have outreach effects by the lawmaker. Although I have seen that here, even in Europe, there's a very reluctant to go on any accommodation. Canadian scholarship also, I would say, and I'm not surprised, are quite sensitive to such issues. Also in the United States, don't want to elaborate on this, but for instance, try to do an approach which transform accommodation, which they have called joint governance minority. Understand this familiar, which I think is interesting. It does not give us a final word about the phenomenon. At least, but I would say at least an attempt to accommodate diversity, which is one for the legal system nowadays. And I don't want to involve you Bertie, in my evaluation, but it seems to me so. Australia trying to point out how much we to work on scientific research to find responsive to the questions that come from politics. Perhaps those of today may have this sort of civic to find nations that might accommodate. Otherwise, I'm afraid the pluralism of Europe are more a mythality. This is a very rude awakening. And so I would finish here, but
yeah, sure.
Okay. Go ahead.
With the question posed by legal pluralism, I would say no. There is no such question, even from newspaper. Everyone see Muslim women asking for Sharia law.
How about the Muslim men? Exist also, do
well, yes. Yeah, but they're not the petitioners. They are not the petitioners. So, and also, well, because it's so great, I focus on the vulnerable parties. We have a responsibility towards the vulnerable parties. And interestingly, so there are some might be quite harsh, especially in this small environment. But I, from the literature, for instance, Oxford University handbooks on Sharia in England, and I say the same for the Netherlands. There are mostly men open for legal pluralism, and it's very interesting because they don't advocate it, but they generally like crazy. I'm reading that, but always goes in a form like this. We should think legal pluralism. We should ability to be intolerant, and we should never allow to harm women's rights. And I called one skate in summer. So people love icing, and they love summer. They think we should think that we can ice. You cannot have legal pluralism and the women's rights at the same time. And these handbooks has ever been able to the reader how to be practically done. So it is brought to legal pluralism, and how are we supposed to do that? Nobody. I find that interesting. Let's to the one say you said it's responsiveness by states, and I say the problem. It's something I greatly applaud, encourage the unresponsiveness of secular states. And I think that the fact of recognition say will make more and lower. It cannot be low enough. And why it's not a principle position, but it is a principle position. It's also a practical position because we're now discussing the need for legal pluralism, also based on demand by us or generation of immigrants. I like to focus on the coming generation, sort of 30, 50 years now, and I think that state-redness will be detrimental to those generations coming. The unresponsiveness and constant focus on sex is actually better for those coming. We have ceased to you say, is that the end tolerant? I would say, yes. And I'm actually not to tolerate if that means that women's rights are violated. I'm very tolerant and actually quite proud.
Very nice. I'm glad that has been accommodated because the uniformity, and I don't like uniformity if it encourages women's rights. So it's Robert.
Very election, and interested. Two little questions. The first one: why do people now go to the Sharia courts? And I to think how they read the four. They see the Sharia is no more, and for this one way, but in Great Britain there are other ways to promote Sharia law through the law of England, for human rights, promote Sharia through Human Rights Act, promote Sharia anti-discrimination law. So this one form of mediation is fantastic because there's no absolute one position, but to find for that what can we do this integration, different models that go together in intersection point. True, from a Muslim idea, religion, but to find the accommodation through the positive law is respect to positive law and respect also religion principles. And for me, this one is the way. So for comparatists, there is a really hard not possible for only the constitutional lawyers, but only for comparatists, because the comparatists have in mind idea of integration, idea to discover similarities. The position also says this.
Okay.
Thank you. Just a comment. I would say that our view, if it's a topic, we can think about a real integration, but it's not in ground. Our theory, there is a critical point that is the so-called dilemmas of difference, in the meaning decide effectively if we have a difference with the equal trait or spatial treatment. So if there is a difference, it's to treat with the different like equal, no? And so is if I treat the different as a spatial norm, as a spatial law, then there is still a difference. And this is also for feminist legal theory. There is that dilemmas. Women want to be treated like men or different by men. Because if they are treated like men, they have to work, they have not some rights for maternity and so on. If they want to be treated as special, are different by men, they are not equal, they are different. So I think this is a very dilemma in our legal theory.
Of course, yes.
Thank you.
Well, thank you very much, and I thank all of the speakers and the participants and the discussants and the audience. In particular, I would say that, and of course those who assisted us, in particular those who have been here since morning until dawn. So thank you very much, because your presence is very meaningful, and it has supported us in our in the elaboration of our thinking. I think it's a very important topic. I'm very glad that we did with it, and I want to have other the possibilities of legal pluralism in Europe, trying to find out whether there is a topic which doesn't affect women's rights. And if it doesn't affect women's rights, perhaps we can get rid of the image that we have of, you said, white, liberal, men. Any reference to age?
Yes.
Yeah, okay.
Of course.
I think it's better to quit then.
I didn't want to worsen it. It was already bad enough.
Okay. No, that's, thank you very much.
Thank you.
In reference to age. But of course, the good part was that connected this prejudiced old man with Cambridge University Press and Oxford University Press. So that's at least.
It was middle age.
Oh, it was middle age. So okay. Also, so I still have time to
Rich
get there.
man, middle age, white man.